I call David Clendon.
Thank you, Mr Speaker. It's no great pleasure to speak to the third reading of this legal assistance bill. There's a great deal one can discover about the bill simply by looking at the evolution of the naming of the bill, which of course started out in life as the Legal Assistance Sustainability Amendment Bill and now has been divided into a number of other bills. But the reason why that name was dropped and why the word sustainability dropped out is quite remarkable, and it's reflected in the report back from the Select Committee. And this is not the minority report, this is actually the report from the majority, from the government members. And the recommendation in that report calls for or recommends a changing of the name of the bill to the Legal Assistance Amendment Bill, and goes on to say the intention of this change is to reflect extensive amendments proposed to the bill in response to submissions, and that's a good thing for Select Committee to do, clearly. But it goes on to say, and I quote, "These proposed amendments reflect the refocusing of the bill on the outcomes for legal aid clients rather than solely on the financial savings to be achieved." Now, I commend the honesty in that statement, but what an extraordinary admission for government to make, that in fact this bill was first drafted solely in order to save money, to make some short-term financial cost with no thought to the outcomes for legal aid clients, those people who are in need of the services in order to see that they are fairly represented in court. As I say, that's a very honest and open admission, but it just reflects how the very narrow scope, the lack of an integrated approach to lawmaking, which this reflects. And sadly, it's a theme that runs through a great deal of the legislation. We're seeing this from this government, an absolute singular focus on cutting costs in the short term, with no recognition of the longer term consequences of the fact that in fact you're making false economies, that saving a dollar in one place is very likely to lead to increased cost elsewhere. And not only financial cost, in this instance, the social cost, the cost in terms of access to justice is simply unacceptable. It's a very thoughtless piece of drafting focused on that with that singular attention to saving money, and that's a very poor way to make legislation. The fact that the original drafting contained what's known, of course, as a Henry VIII clause, that is effectively a power for the minister to actually change the law, to make amendments in a way that really to exercise the power of the Parliament. Again, to me, that reflects with no sort of ill will towards the drafters, clearly, those very hard-working officials who do the work, but the fact that the public sector has been driven down to a point where it's scarcely able to fulfil its core functions. Again, this short-sighted, narrowly focused cost-cutting that simply leads to poor outcomes in the longer term. So access to justice clearly is going to be limited by the fact that people will be increasingly have difficulty in getting access to legal aid. The fixed fee that's introduced in this bill, the application charge, $50 or so, we know that that will mean that there will be fewer companies who are actually interested in providing legal aid services. We're hearing this already from larger legal practices, that they simply won't bother with legal aid work. They cannot. There is, I think, within the legal profession, there is a degree of corporate responsibility, there is some pro bono work done and all that. But frankly, these people are running businesses. And on the fixed fee scale that's proposed in this legislation, the regulations, it simply won't be worth the candle for companies to involve themselves. There will be increasing demand for legal aid, a reducing supply, and there will be fewer people who are able to get the representation in the courts that our constitutional basis really requires that they should have. So this reflects we will get this very unfortunate situation where we'll have the best access to justice that money can buy. The quality of the representation people will receive in courts will be a function of their ability to pay for that. And that's a very unhappy situation for New Zealand to be in. This country over the last 20-odd years has seen a widening inequality gap. Fewer people are doing very, very well, and more people are actually not doing well at all, and in fact are struggling simply to survive. Some members may have seen a presentation earlier this evening, a new book that's been published recently, the editor Max Rashbrook, called Inequality in New Zealand. And chapter after chapter describes across the board in society in all sorts of sectors, all sorts of ways, that inequality gap is opening up in New Zealand. And now we're seeing unequal access to justice, and that's simply unacceptable in a modern liberal democracy. So we know that where the wider that gap, that inequality gap, as it widens, it disadvantages not only those at the bottom, but even those who are best off in that situation financially, actually are overall worse off because of the quality of the social the norms of society degrade, and that's to nobody's advantage. Everybody is worse off as we allow this inequality gap to expand and to open further. Inequality, unequal access to justice, unequal access to representation in our courts is a serious matter. Unfortunately, this bill makes that situation worse. We've heard from one member at least who talked about this bill striking a balance between saving money, cost-cutting, efficiency, however you like to describe it, and access for justice. In fact, this bill fails miserably in terms of balance. It is a very unbalanced piece of legislation, and we can go back to the original point I made. The point of this bill is to cut the cost, to take dollars off one or two lines in the justice budget, not actually accepting that what we're really doing is relocating cost. We're saving money in one point, we're upping the cost somewhere else. A lot of that will be felt by the most vulnerable, by the poorest. It'll mean fewer people get decent representation, more people stay longer in the justice system, and increase of people being convicted, paying fines, even being imprisoned, who ought not to be, arguably. This is a very poor piece of work. It is not a balanced approach to lawmaking. It is not a balanced approach to justice, and the Greens will continue to oppose this.
The Honourable Trevor Mallard, point of order.
I apologise to the member. Mr Speaker, following the request of the member in charge of the bill and discussions